Come to our comprehensive guide on the Securities and Exchange Board of India, or SEBA. Established in 1988 and granted statutory power in 1992, SEBA plays a pivotal role in regulating India's securities market. Before SEBA, the securities market was governed by a patchwork of laws, leading to confusion and inefficiency. The government recognized the need for a unified regulatory authority to protect investors, promote market. SEBA's primary objectives are threefold: protecting the interests of investors in security, promoting the development of the securities market, and regulating the market to ensure transparency and fairness. These goals are enshrined in the SEBA Act 1992, which extends across India. As the watchdog of the securities market, SEBA's role is crucial in maintaining investor trust and fostering a healthy environment for capital formation by setting clear rules and monitoring. Understanding SEBA's framework starts with key definition. The board refers to the Security and Exchange Board of India itself. A collective investment scheme is any arrangement pooling investor funds for return. Judicial member and technical member are roles within the Securities Appellate Tribunal, while regulations are rules made by SEBI under the Act. The term securities is defined as per the Securities Contract Regulation Act 1956. SEBI was established as a body corporate with perpetual succession and a common seal. It has the authority to acquire, hold, and dispose of property, both movable and immovable, and to enter into contracts. The board's head office is in Mumbai, with the power to set up offices elsewhere in India. The management of SEBI is entrusted to its members, appointed by the central government, ensuring that the board is led by individuals with expertise in law, finance, economics, and administration. SEBI board consists of a chairman nominated by the central government, 2 members from the Ministry of the Central Government, 1 member from the Reserve Bank of India, and 5 other members nominated by the central government, with at least 3 being whole-time members. All members must possess integrity, ability, and relevant experience. This diverse composition ensures a balanced approach to regulation, drawing on expertise from various fields to address the complex challenges. Chairman and whole-time members of SEBI serve terms not exceeding 5 years, with eligibility for reappointment, but cannot serve beyond the age of 65. The central government holds the right to terminate their services with notice or compensation. Members can also resign by giving notice. Removal is possible if a member is insolvent, of unsound mind, convicted of an offence involving moral turpitude, or abuses their position. However, no member can be removed. SEBI's board meets as per regulation, with procedures for quorum and decision-making. If the chairman is absent, members present choose a presiding officer. Decisions are made by majority vote, with the chairman or presiding member having a casting vote in case of a tie. Members with a conflict of interest must disclose it and abstain from related discussion. Importantly, vacancies or procedural irregularity do not invalidate board decision, ensuring continuity and stability in SEBI. SEBI's powers are extensive and designed to protect investors, promote market development, and regulate the securities market. These include regulating stock exchanges, registering and overseeing market intermediaries, prohibiting fraudulent practices, promoting investor education, and preventing insider trading. SEBI can also conduct inspection, call for information, and coordinate with other authorities. These powers enable SEBI to act swiftly and decisively to maintain market. SEBI is vested with powers similar to those of a civil court. It can summon and enforce the attendance of persons, examine them on oath, require the discovery and production of documents, and inspect books and records. SEBI can also issue commission the examination of witnesses or documents. These judicial powers are crucial for conducting thorough investigation and ensuring compliance with securities law. SEBI can take a range of enforcement action, such as suspending trading of security, restraining persons from accessing the market, suspending office bearers, impounding proceeds, and attaching bank accounts or property. These measures can be taken during or after investigation to protect investors and the market. SEBI must provide an opportunity for a hearing before or after passing such orders, ensuring due process is followed. Penalties imposed by SEBI are credited to the Investor Protection and Education Fund (APF). This fund is used to educate investors and protect their interests. SEBI can levy penalties for violations of various provisions, and the amount disgorged from wrongful gain is also credited to the APF. This mechanism ensures that penalties serve a constructive purpose, reinforcing SEBI's commitment to investor protection. Let's consider a practical example. If SEBI receives information that a registered broker, such as DA Brokers Limited, has violated regulations, it can order an investigation. SEBI appoints an investigating authority to examine the broker's affairs and report back. This process ensures that any suspected wrongdoing is thoroughly investigated and appropriate action is taken to maintain market integrity. SEBI has been delegated several powers previously held by the central government under the Securities Contract Regulation Act 1956. These include calling for returns from stock exchanges, inspecting their books, approving or amending bylaws, licensing dealers, and overseeing public issues and listing. SEBI can also delegate its power and administer certain provisions of the Companies Act 2013 related to listed company. This consolidation. SEBI regulates or prohibits the issue of prospectuses, offer documents, or advertisements soliciting money for security. It specifies conditions for issuing such documents, including disclosure requirements and eligibility criteria for listing and transfer of security. By setting these standards, SEBI ensures that investors receive accurate information and that companies adhere to fair practices when raising capital. Collective Investment Scheme (CIS) is any arrangement where investor contributions are pooled and managed for return. SEBI regulates CIS to protect investors from fraudulent schemes. Certain exceptions exist, such as schemes by cooperative society, insurance contract, pension scheme, and mutual fund. Any unregistered pooling of funds above a specified threshold is deemed a CIS and must comply with SEBI regulation. SEBI can issue directions to companies or market participants to protect investors, ensure orderly market development, or secure proper management. It can also levy penalties for violation after conducting an inquiry. These powers include directing disgorgement of wrongful gain, ensuring that those who benefit from violation are held accountable. This authority is essential for maintaining discipline and fairness in the market. SEBI suspects market manipulation or violation. It can order investigation. All relevant persons must preserve and produce documents for the investigating authority, which can retain them for up to 6 months. The authority can examine individuals under oath and, if necessary, seek court orders to seize documents at risk of destruction. These procedures ensure thorough and lawful investigation. SEBI finds that a person has violated or is likely to violate securities laws. It can issue a cease and desist order. This order requires the person to stop the offending activity. However, such orders against listed company are only issued if there is reasonable belief of insider trading or market manipulation. This tool helps SEBI act quickly to prevent harm to the market. SEBI requires all market intermediaries, such as brokers, merchant bankers, portfolio managers, and others, to obtain a certificate of registration. This ensures that only qualified and compliant entities operate in the market. SEBI can suspend or cancel registrations for violation, but must provide a reasonable opportunity for the concerned party to be heard, upholding principles of natural justice. SEBI strictly prohibits manipulative or deceptive devices, insider trading, and substantial acquisition of securities or control without compliance. No person can engage in fraudulent acts, use unpublished price-sensitive information, or acquire control beyond prescribed limits in violation of regulation. These prohibitions are vital for maintaining market fairness and protecting investors from unfair practices. SEBI's finances are managed through the Securities and Exchange Board of India General Fund, which receives grants, fees, and other income. The board's accounts are audited by the Comptroller and Auditor General of India, ensuring transparency and accountability. Annual reports and audit findings are submitted to the central government and laid before Parliament, reinforcing SEBI's commitment to good governance. SEBI can impose penalties for a wide range of violations, such as failure to furnish information, non-compliance with agreements, and defaults by mutual funds, asset management company, and stockbrokers. Penalties vary based on the nature and duration of the offense, with strict limits to ensure proportionality. The adjudication process includes a fair inquiry and the right to be heard, maintaining procedural fairness. Insider trading attracts severe penalties, including fines up to 25 crore rupees or 3 times the profit made, whichever is higher. Similarly, failure to disclose shareholding or comply with takeover regulations can result in hefty penalties. These strict measures deter unfair practices and reinforce SEBI's commitment to market integrity. Engaging in fraudulent or unfair trade practices can lead to penalties ranging from 5 lakh rupees to 25 crore rupees or 3 times the profit made. SEBI also penalizes tampering with records, unauthorized access to regulatory databases, and assisting others in such acts. These provisions ensure that the market remains transparent and trustworthy. SEBI appoints adjudicating officers to conduct inquiry and impose penalties. These officers have powers to summon witnesses, demand documents, and assess the facts. If the board finds an order unjust, it can enhance the penalty after giving the concerned party a chance to be heard. All penalties are credited to the Consolidated Fund of India, ensuring public accountability. Securities Appellate Tribunal (SAT) is established by the central government to hear appeals against SEBI's orders. SAT consists of a presiding officer, judicial members, and technical members, all appointed based on strict qualification. The tribunal operates through benches, primarily in Mumbai, and ensures that parties have a fair opportunity to appeal SEBI's decision. Members of SAT are appointed by the central government, with input from the Chief Justice of India or a nominee. Technical members are selected by a committee, including the presiding officer and government secretary. Members serve 5-year terms, with a maximum age limit of 70 years. These provisions ensure the tribunal's independence and expertise. SAT is not bound by the Code of Civil Procedure but follows principles of natural justice. It has powers similar to a civil court, including summoning witnesses, requiring document production, and reviewing decisions. Proceedings are judicial in nature, and the tribunal can transfer cases between benches as needed. This flexible approach ensures efficient and fair resolution of appeal. Any person aggrieved by SAT decision can appeal to the Supreme Court on questions of law within 60 days. The Supreme Court may allow further time if there is sufficient cause. This multi-tiered appeal process ensures that all parties have access to justice and that SEBI's actions are subject to judicial review at the highest level. Central government has the power to issue policy directions to SEBI and, in extreme cases, to supersede the board for up to 6 months. During supersession, all powers and property of SEBI vest in the government. After the period, the board can be reconstituted. These checks ensure that SEBI remains accountable to the public interest. SEBI must furnish returns and reports to the central government, detailing its activities and financials. Annual reports are submitted within 90 days of the financial year's end and presented to Parliament. This transparency ensures that SEBI's operations are open to public scrutiny and that it remains answerable for its actions. Violations of SEBI's provision can result in prosecution, with penalties including imprisonment up to 10 years and fine up to 25 crore rupees. Offences are tried by special courts established by the government, ensuring speedy trial. Certain offences can be compounded by SAT or the court, providing flexibility in enforcement. Central government can grant immunity from prosecution or penalty if a person makes a full and true disclosure of violation. Immunity can be withdrawn if conditions are breached or false evidence is given. Additionally, actions taken in good faith by SEBI or government officials are protected from legal proceeding, encouraging proactive regulation. Special courts consisting of experienced judges are established to try offences under SEBI's jurisdiction. If a company commits an offence, persons in charge and responsible are deemed guilty unless they prove lack of knowledge or due diligence. Directors, managers, and officers can also be held liable if the offence was committed with their consent or due to their neglect. If a person fails to pay penalty or comply with SEBI's orders, the recovery officer can attach and sell movable or immovable property, bank accounts, or even detain the person in prison. These recovery provisions are modelled on the Income Tax Act, ensuring effective enforcement of SEBI's orders and protecting the interests of investors and the market. Central government and SEBI have the authority to make rules and regulations to carry out the purposes of the SEBI Act. These rules cover a wide range of matters, from service conditions to procedural requirements. All rules and regulations must be laid before Parliament, ensuring legislative oversight and adaptability to changing market needs. SEBI listing obligations and disclosure requirements. Regulation 2015 or LODA consolidate and streamline listing conditions for various securities. These regulations apply to all entities accessing the stock exchange for listing equity shares, debt security, mutual fund units, and more. LODA ensures uniform disclosure standards and corporate governance across listed entities, enhancing market transparency. LODA applies to all listed entities, regardless of their structure, if they have listed designated security. The regulations are divided into substantive provision and procedural schedule, covering everything from board composition to periodic disclosure. This unified approach simplifies compliance and ensures that all listed entities adhere to the same high standard. LODA mandates that boards of listed entities have an optimum mix of executive and non-executive directors, with at least one woman director and a specified proportion of independent directors. The top 1,000 entities must have an independent woman director. These requirements promote diversity, independence, and effective oversight in corporate governance. Boards must meet at least 4 times a year, with a maximum gap of 120 days between meetings. The quorum includes at least one independent director. Boards are required to review compliance reports and evaluate the performance of independent directors, ensuring accountability and continuous improvement in governance practices. LODA sets limits on the number of directorships and committee memberships a person can hold. No individual can be a director in more than 7 listed entities or serve as an independent director in more than 7. Committee memberships are also capped to ensure directors can effectively fulfill their responsibilities without being overextended. Listed entities must ensure at least one independent director sits on the board of material unlisted subsidiary. The audit committee reviews subsidiary financials, and significant transactions must be reported to the parent board. These measures extend good governance practices throughout corporate groups, protecting minority shareholders and ensuring transparency. Annual reports must include detailed disclosures on corporate governance, including board composition, committee structure, meeting attendance, and related party transactions. Companies must also disclose compliance with monetary and non-monetary requirements, whistleblower policy, and any penalties imposed by SEBI or stock exchanges. This transparency builds investor trust and market credibility. Listed entities must file quarterly reports on investor complaints, corporate governance, shareholding patterns, deviations in fund usage, and financial results. These filings ensure ongoing transparency and allow SEBI and investors to monitor the company's compliance and financial health throughout the year. Further requires listed entity to give prior notice to stock exchanges about board meeting, especially when considering financial results or significant proposals. This advance intimation ensures that all stakeholders are informed and can make decisions based on timely and accurate information, further enhancing market transparency and fairness.